Hello friends. So SEBI has issued a consultation paper on PIT regulation 2015 on 24th November 2023. This consultation paper is related to the trading plan provisions. So SEBI has realized that due to the very stringent requirement which has been prescribed in the current PIT regulation 2015, very few person has used the trading plan mechanism to trade in the markets in the past. It is a need of the time to relax certain requirements and make it more user friendly. So let's try to understand this consultation paper through this presentation. Since this consultation paper is related to the trading plan, so it is very important to understand the trading plan mechanism under the current PIT regulation. Then we will discuss what are the proposed changes. So let's understand first what is trading plan. So in a simple language, if I would explain what is trading plan, so under the trading plan, an insider in advance disclose his trade, basically number of shares and the timing of his trade, and disclose the same to the compliance officer for his approval. And once the same is approved by the compliance officer, the same shall be disclosed to the stock exchange. This route of trading is generally adopted by those person who always have a UPSI. This is a kind of broad structure, I would say, of trading plan. Let's also understand few other nuances as well with respect to trading plan. As you can see, the first uh, aspect of the trading plan is the commencement of the trading plan shall be happened after the 6 months from the public disclosure. And if I would talk about the rationale behind it, so generally it is presumed that if you have any UPSI or any insider have any UPSI, that may become public in the 6 months time. So ideally at the time of his actual trade, as per the trading plan, there will be no UPSI he will have, whatever be at the time of formulations. But if it does not happen so, then the compliance officer can defer the implementation or commencement of the trading plan. The second point, as you can see, the trading period shall not be less than 12 months. And third, very critical, there is no applicability of contra trade restrictions on the trades mentioned in the trading plan. So this is, I would say, the bird eye view. So the proposed changes in the trading plan provision are as follows. So as we have studied that commencement of trading plan shall start after the 6 months from the public disclosure, they have reduced this time period from the 6 months to 4 months. And the second is trading period shall not be less than 12 months. So they propose to reduce to 2 months. And the last one is, as of now, the contra trade restriction shall not be applicable on the trade which are mentioned in the trading plan, but they have proposed that the contra trade restriction shall be applicable on the trade mentioned in the trading plan. Apart from it, SEBI has also said that this trading plan shall has to be disclosed within the 2 days, and they will also prescribe the specified format. So far, there is no specified format under the current regulatory regime. And last one is very important and pertinent as well, and the price limits. So insider shall have a flexibility during the formulation of the trading plan to provide the price limits. That is, he can prescribe the upper limits for buy trades and the lower price limit for the sell trade. And such price limit shall be within 20% of plus minus, you can say, on the closing price of the trading plan, whatever be the day he submit. So the significance is that if the price of the share during the execution is outside the price limit set by the insider, the trade shall not be executed. This is a kind of protectionism or protection for insider from the too much fluctuating in the price which the insider has already decided in advance while submitting the plan. So this will protect definitely the loss of insider, and this probably will help if this will become the law. SEBI has also raised the privacy concern while disclosing, and this is also, a very talk about topic, since personal data protection bill has been passed. So while submission of the trading plan, there are a lot of personal information of that particular insider has been in the public domain, like PAN number, designation, and the name. So SEBI has thought about, instead of giving all the informations to in the public domain, that would be a safety and the privacy concern definitely raised by the industry people. So they have, I would say, it's not very concrete. They provided three options. So how they can, incorporate the personal details in the trading plan. So first they said, let's hide the personal detail of the insider while submission of the trading plan. Under option two, they have suggested continue the existing practice, whatever be the details has been captured under a trading plan, that will be submitted to the market participant or the public through the stock exchange disclosure. The three the option three is a kind of, I would say, there is some creativity which SEBI has shown. They said you or the company can make the two disclosure. First, full disclosure with all the confidential information which remain confidential with the stock exchange. So first filing would be only for consumption of stock exchange. It will not go in the public domain. And the second disclosure is like without the personal details to the public through stock exchange, which generally company does in the normal course of their disclosure. So these three option has been envisaged. So far there is no certainty which option will go into the fine prints when this become the regulation, but yes, SEBI has very aptly, touch upon the privacy concern, which is again good initiative by the SEBI to take care of the privacy concern. And SEBI has prescribed the last December 15, 2023 as a last date to provide your comments. With this slide, I would end this session. I hope you like it. Thank you for watching this video.